Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. I just got back from court arguing a motion for summary judgment. And while I've covered that before, I thought it might be helpful to go through this again. What exactly is a motion for summary judgment? How can you use that? How can that be used against you? And if you're responding to a motion for summary judgment, what in the world do you do? So for this particular video, I'm going to use this in the context of a debt collection lawsuit. So you've been sued by a debt collector, by an original creditor, and so that's the context we'll use. So what is a motion for summary judgment? Well, it simply is where one party, could be the plaintiff, the one who filed it, or the defendant, the one who was sued, says to the judge, there's no reason for a trial, just summarily enter judgment because all the facts are in my favor and the law's in my favor, so there's no reason to hold a trial. And so, like I said, either party can use it. So could you use this as the defendant? You could. It would be unusual in a debt collection case. You would have to show that the facts that are out there just do not support at all the plaintiff's case. Okay, so more commonly, and look, that's a more advanced tactic, you doing this as the defendant. More commonly, the plaintiff in a debt collection case will file this against you. And think about it, because they've got the account information, they've got the statements, they'll get an affidavit from somebody that says, hey, we bought this debt, if it's a debt collector, or we're the original creditor, you owe this money, you didn't pay it, and boom, case is over. Okay. And so they want this so that there's no discovery, okay, and no trial where they have to bring a witness in. And so how do you defend it? Well, what you have to do is make sure you understand it's typically Rule 56. In federal court, it's Rule 56 of civil procedure rules. In Alabama state courts, Alabama Rules Civil Procedure 56. Most states are going to follow that model. Not all states, but most states. And so you'll have a rule called summary judgment. And it will tell you what the person filing the motion, who's moving for the summary judgment, what they have to prove, how they have to get their evidence in. And then you, as the defendant, how do you respond? So most places, but again, check yours, you have to file a response in court, in other words, with the clerk's office, and typically give the judge a copy 2 days before the hearing. Now, usually that's 2 business days. Some judges say, I want it 5 business days. I mean, you got to know for your state and your local judge, what is his or her rule on that? And you have to put forth any facts that you want. So if the plaintiff, let's just say the plaintiff is a debt collector, if they have put forth enough facts that show that they own the debt and you owe the debt in the amount that they say you owe, well, then you may need to put forth evidence. So it could be an affidavit, could be other admissible evidence that shows that you do not owe this or that they do not own it. So imagine that the debt collector says, all right, this started off at Synchrony Bank, and then it went to Midland, and then it went to LVNV. Okay. But the evidence they show just has that it went from Midland to LVNV. There's nothing showing it actually went from Synchrony Bank to Midland to LVNV. Well, that's something you could point out. There's a failure of proof. So you might make the judgment call. Obviously, if you're doing this on your own, you make this judgment. Hey, I don't need to put forth any evidence because they failed to show the chain of title, or they failed to show the amount. I mean, this is pretty classic. And I've been successful with this, not saying that you will in your state or with your judge. You have to figure that out. But let's say that they claim you owe $10,000 and they attach 3 statements, 3 monthly statements from the credit card. And the oldest statement has a starting balance of $4,321. And then they show the next statement, then the next statement. Well, how do we get that starting point of $4,321? Maybe the other statements are good proof for them, but they're only proof from this point. They've got to go back in time. How did we get to $4,321? Well, I had this statement, it was $200, and then it was $500, and then $1,000. I mean, I think they have to show all that leading up to the statement. So they really need to show from the last time you were at a zero balance to the final amount. If they don't do that, I think they have a failure of proof. So again, you may make the judgment call, I don't need to put forth any evidence because they haven't met their burden of actually showing that the facts are in their favor. Now, they may show that, and you may need to put forth evidence, hey, I disagree, this was not the correct statement, or they charged the incorrect interest amount, or I wasn't late when they say I was late, whatever your evidence is to argue against this. But it has to be submitted in the proper form, and so many people do this on their own, they just miss this. They just say, well, I'm going to show up at hearing, and I'll just have a bunch of papers, and I'll be there to testify under oath. Well, they get there, and the judge is like, we're not taking testimony. The time period to get your evidence in was 2 days ago or 5 days ago or however long ago it was. And so you're there with a stack of documents and all these words you want to say, and you can't say anything. So you've got to get your evidence in at the right time in the right format, file it correctly, and you have to figure all this out with your court, with your rules. And then you need to put a legal argument in front of the judge. And again, typically that has to be submitted at the same time as your evidence. So they file the motion and they'll have arguments in there. Sometimes it's all in one document. Sometimes they have what's called a memorandum of law in support of their motion for summary judgment. And you need to respond to that and show why they're wrong. So you cite case law, statutes, whatever it is that you argue here. So you've got your evidence and your argument. And if you do both of those in the right way, the right time, and the right format, and then you go to court and you argue that successfully, then you win. Now, when I say you win, it means you defeat the motion for summary judgment. That doesn't mean you win the case. It just means, the case started off here and it's heading toward trial, and they put up this motion for summary judgment to stop it and say, we don't even get to trial. Well, that just gets removed and then it goes on to trial. So if you're handling one of these on your own, I would just tell you that these are difficult for most people to handle on their own without a lawyer. So if you're in a state where maybe a lawyer can do what's called limited engagement or limited representation, maybe you hire a lawyer just to help you write a response to that. Well, that's an option. Or hire a lawyer to handle the whole matter for you. And if you're doing it on your own, just understand, you're not spending money on a lawyer. You better spend a lot of time and figure out what works in your state. And look, there are people that sell responses that, hey, you can buy this package from me. And those can have some value. But understand what works in Mississippi may absolutely not work in Alabama. Or what works in Alabama may not work in South Dakota or in Texas or California or Florida. Totally different rules. And so you really need to understand, even if you're buying something from somebody that supposedly will give you all the answers, you're going to have to interpret that into your language. When I say your language, I mean your state's rules and your particular judge. Okay? So I practice all over Alabama. And I practice in other states when people get us involved in cases in other states, typically in federal court. But the rules are different. What one judge will accept in Madison County or Limestone County, that's at the top of the state, is different than what maybe this judge in Jefferson County, which is Birmingham, or this other judge in Jefferson County. And then you have Montgomery, and you have Mobile, and you have, Dothan, all these different places all across the state, up and down and left to right. And judges do things a little differently. And so you really need to know for your judge, your state, your rules. And if you're going to do this on your own, just understand the risk. Somebody is trying to do, in essence, a knockout blow here to win the case, get a judgment against you, and then start garnishing your wages, your bank account, put liens on your property, sell your property, whatever your state allows in terms of execution of judgment. So it's very serious. So either get help or make sure that you are completely prepared to handle this. So good luck with everything. Appreciate you watching this video, and I'll catch you tomorrow. Bye-bye.